Part 1. I am going to discuss that how to teach cyber law. We know very well that before 1995 there was no challenge about the cyber laws, because for the first time in India we have seen internet came in 1995, and then we started providing the services to the users and also provided the websites and all. People can use cyberspace for goods and services. Because before that things were mostly happening in the physical mode, so there was no challenge about the rights and liabilities of the people who want to use these services. Before going in detail about the cyber law, let us see the growth of internet, how it started. We know very well that in 1968, for the first time, US agencies, they started using the cyberspace for defense purposes. So they use the ARPANET because they were trying to see how they can fast communicate with the defense services and coordination, so they can take fast action. And it was great success that they were able to coordinate very properly with the ARPANET. And then debate started that can we expand this kind of use for the other services. Then there were a lot of discussion started at global level. Can we use cyberspace for commercial purposes? And then after 1980s there were a lot of discussion at the international forum, and then we discussed that let us use for the commercial purposes. And then it was started used to use for the research, because for research the main challenge is that how to get the material and how to fast we can access, because earlier days we used to go to different libraries and try to find out the material. It was very challenging to travel throughout the country to find the real resources, because if you go to the library, material may not be available or material may not be latest. Then shifting from the general research material to the online mode and how to use the internet for research purposes was the great benefit. So it was discussed that now let us use the cyberspace for research purposes, and it was great success. So in 1996 in the model law of e-commerce, m-commerce, it was discussed that let us have the proper regulation model and given to the all countries in the world. They can be kind of a platform that how to use the internet for the commercial purposes, and all the member countries who signed the model law e-commerce and m-commerce, and they went to their countries and trying to make the law for their country. And accordingly, after signing the model law of e-commerce in 1996, the Government of India wanted to frame a law for the country, and then it was given to the Ministry of Commerce, but they could not make a law, and then it was shifted to Ministry of IT. So Ministry of IT, they had a lot of deliberation in the country and trying to see that how in Indian scenario we can have the level playing field for e-commerce and m-commerce, and we can have the regulation for the country. Then we are able to have the IT Act 2000, and it was came into force on 17th October. So 17th October 2000 is the birth of cyber law in the country, and then it has amended IPC, banking laws, and also CRPC. Because before that the electronic evidence was not mentioned in the CRPC, and the question was that records were just a record, and now once we are going to use the cyberspace, there will be electronic records. So it has amended the 65B, and 65B of the CRPC says that electronic records are the records. So once we are saying electronic records are the records, in that case anything happening in the online mode and any data generated in the online mode can be given to the court of law in the form of evidence, and court will accept that record as an electronic evidence. So it means that the real core is from B of the CRPC, where it says that electronic records are the records. Then we have also amended the banking laws. We amended the IPC, because the nature of crime happening in the cyberspace is different than crime mentioned in the IPC in the physical mode, because the nature of those crime happening in the cyberspace is very kind of challenging, very fast and very serious. Impact will be very large. So that's why the debate was that can we have same kind of liability what is mentioned in IPC, or we can have different liability, because if something happening on the cyberspace, use of technology or multimedia, because the boundary is global. If you see the criminal law, it talks about that local crimes, or maybe because everything is decided by the place of the crime, where the issue rose and where to file the suits. But if you go to internet, it's very challenging to find out the place of the crime, and the timing of the crime, and also the boundary. So fixing the liability and fixing jurisdiction was a big challenge in the kind of cyberspace. Then we have seen that because of the internet, because if you do anything in physical mode, you require property, you require a space. So it is governed by the Transfer of Property Act. But if you go to cyberspace, you require a space to start a shop or start a website. You require a space where data will be stored, and then you will be hosting your website. Then in that case, people started misusing all the big kind of trademarks and trying to use those names as a website name, as a domain name on the internet, and people used to go on copying lot of websites. For example, Wipro company, somebody registered 7 websites, wiprosr.com, hashimpremji.com, and they were trying to show that they are the real Wipro company and they are going to promote the business. But they were doing cyber squatting, because without permission from the Wipro company, they were going to register the domain name. But at that time, there was no prescribed law how that somebody can go for taking domain name. People have taken the Times of India, they have taken the SBI.com, because there was no regulation. Then the case was filed in Delhi High Court in the Yahoo versus Akash Arora. For the first time, Delhi High Court, they have said that those company who have the trademark registered in their name, they have the right to go for getting the domain names. And those who are trying to misuse these places, they are doing cyber squatting. So it was a Delhi High Court case, and then again the matter was rose in the kind of Satyam versus Satyam Infoway case. In that case, the issue was that because somebody has made a website of Satyam and they are selling these softwares, they are doing a lot of business, and they are showcasing that they belong to a Satyam company. Satyam was at that time a market leader in the software development and software services. And it was realized that the other company who registered the Satyam on the domain name, they were not the real company. They were trying to utilize the goodwill of the Satyam company. And because the Satyam, they are saying it is belong to the 6 partners, but Satyam actually, in fact, it has not satisfied all the first letter of the partners. So they have lost the case. And Supreme Court then ratified the Yahoo Akash Arora case and said that the domain names are trademark. So matter was settled in 2005 that those company who has the registered trademark, only they will be having right to have the domain names. Because in domain names, by simply changing one alphabet or changing the kind of comma, kind of the dots, you can have the different domain name. But if you talk about the law of torts, it says that anybody who is trying to utilize somebody's goodwill, it will not be allowed, because whether it is registered or not registered. So prior user concept is there in the trademark, in the law of torts, and but trademark says that unless you are registered your name, because trademark talks about the class specific and area specific. So you can take a name for a class and particular area, and then if you are registering those things, you will be getting the trademark. If you registered, you will get the benefits. If you are not registered, you can take benefit in the law of torts as a prior user. So, but in this 10 years time, there were a lot of people misuse the lot of kind of the brand names, and they did a lot of business without any investment. So they acquired the goodwill of those companies. Now this our IT Act 2000, the whole idea was to provide the level playing field for e-commerce and m-commerce. So the challenge was that how to provide the proper place for doing the online contracts or e-contracts, click wrap contracts, and then the issue was that how to provide the payment mechanism for any contract. The consideration is the big challenge, that how to pay the online and then how to sign the online. So then we have the concept of the click wrap contract, shrink wrap contract, and then online contracts, and the payment mechanism was developed. And then in India we followed the kind of electronic signature with the 2 key infrastructure, private key, public key model is developed, where you can ensure that if somebody is signing anything, then we can verify from the private key and public key model. In fact, it also amended the banking laws, because the payment in the online mode is governed by the banking laws and the Negotiable Instruments Act. Because if you pay in the kind of the by check or draft in the offline mode, it is very easy, but if you are paying in the online mode, it is a very big challenge. Now the question is that because we started for the focusing on the business model as e-commerce, m-commerce, and then now this shifting very fast to the traditional model, where we are going to see that it is also used for other purposes. For example, during pandemic, we realized that even the online mode or maybe mobile mode or internet can be used for all several services. We could survive because of the internet in the pandemic, because everything was shifting to the internet, and we are able to run the in fact the our universities and colleges. We are able to buy services from the Amazon or from the online portals, and we paid online. So it means that now very fast the traditional things are shifting to the online mode or by internet. So now the question is that how we can ensure the privacy and security of the persons who are engaging. In fact, now there is a lot of challenge happening at the international level. We have seen that in the last year, when there was a fight between India and China, India has gone to close 200 applications of China. You can say that why India is going to close the Chinese applications, how it is relevant to fighting aggression on the border line and closing the applications, because those 200 applications, they were capturing a lot of information from the Indian citizens, and then they are passing to the kind of Chinese government. Those information can be analyzed and can be used against Indian interest. So the it means that now the cyberspace playing very important role for the kind of privacy issues, and those private information can be analyzed and can be misused. Then now we have seen that more advanced form is that now the social networking sites, because in social sites is also the global place. Anybody can open the account without payment of the price, and in those places sometimes we feel that we are getting the free services, but it's not free. In fact, if you are using the social sites, we are going to share a lot of information. We are saying it is not private. And then in moment of excitement, sometimes we share our the marriage party photographs, sometimes we share our kind of the personal photographs. If we are going to the family on some of the trips, we share the photographs, information, and sometimes without understanding the complexities, we share. Even in fact, we have seen that the last election of the USA, and then there were a lot of use of the kind of social media for changing the kind of flavor and interest of the voters. Because in a case, we have seen the Supreme Court of USA said that the AI and also the analysis of the social media, or we can say data analytics is a fast growing area. So if you analyze the people what they are sharing on the social media, if you do a lot of analysis, you will understand that people have a lot of kind of aspirations, a lot of you can say the feelings and a lot of flavor. Now they are going to have some kind of AI which will track the information, and it will trying to change the kind of flavor and interest, and then they may be also trying to favor somebody they were not favoring. So they were trying to use the social media for changing the interest of the person, so they can do voting in favor of some other party which they were not favoring. So this is the kind of lot of use is happening of the internet, and they are trying to use for the political purposes. That is not the good efforts. That's why once we are sharing anything on the internet, we should be very careful that what we are sharing is very, very important. Then because the IT Act was framed providing the level playing field for e-commerce, m-commerce, and then we have seen a lot of misuse happening for the IT Act, and then we went to amending the IT Act in 2008, which was came into force in 2009. And it has added so many, around 17 types of things are added. And also we have amended the section this 66 of the IT Act, and we added A, B, C, D and E, and also some other sections were added. And then in the serious single case, we have seen that 66A was by Supreme Court of India. It is said that it is unconstitutional, because in the Shahin Dahada case, what happened after the death of the Bal Thackeray, some lady, she posted something on the Facebook, and one friend has a light from Pune, and police arrested both the persons, saying that it is kind of they're doing a lot of defamation to the Bal Thackeray and the family, because if he has died and if the market was closed, how they can question their kind of this statement. So it was a lot of misuse happening of this kind of statement, and that's why Supreme Court said that in serious angle case, the right to freedom of speech and expression on internet is a fundamental right, and that's why it was kind of conflicting with the write in 19 class 1 and 2 of the Indian Constitution, and they said that it is unconstitutional, so it was shut down. Thank you.